And I wanted to talk to everyone today about what I think is a big hot button issue in the media today. And it's also something that you're probably learning about in your classes here if you've taken constitutional law, or that you will learn when you take constitutional law. And that is the constitutionality of President Trump's executive orders. And in doing this, I wanted to focus in particular on three of his executive orders. I know he's issued a number of executive orders. I wanted to focus on the travel ban. And actually, I'm probably going to focus most of my time on President Trump's travel ban, considering how much media attention that has received and how current that is right now. But I want to talk at the end briefly about his executive orders on immigration enforcement and law and order. Although there hasn't been any litigation surrounding those two executive orders, I think there are a number of interesting constitutional issues that arise with those as well. But most of you have probably heard about President Trump's travel ban, and you can see legal analysis in the media, online. The first travel ban, I want to just give you first a brief history of what's been going on, and then I want to talk about some decisions that were handed down actually yesterday. We couldn't have picked a more timely topic to be discussing today, given the fact that we just had new orders from district courts coming out on this issue as recently as yesterday. But first, to give you some history on this, the first travel ban that President Trump issued, his executive order, was titled Protecting the Nation from Foreign Terrorist Entry into the United States, and it was signed on January 27th. As I mentioned, I'm sure most of you have heard of this order. It blocked citizens of Syria, Iran, Iraq, Libya, Somalia, Sudan, and Yemen from obtaining visas for at least 90 days, and it suspended the entire U.S. refugee program for 120 days. Additionally, it suspended the admission of Syrian refugees indefinitely. Once the refugee program picked back up, it also included a provision that would have given preferential treatment to people who were members of a minority religion, which the president indicated was designed to benefit Christians. That's the first travel ban, and I've been using the past tense because, as most of you have probably heard, it has been struck down, or at least it was temporarily halted on constitutional grounds. And so I wanted to talk about that in depth and more detail perhaps than what you've seen in the media. Okay, so the travel ban litigation for this first order involved a number of different issues here. I'm going to focus on the litigation that took place in the Western District of Washington, because that's the litigation that ultimately led in the travel ban being blocked. It was the district court in the Western District of Washington that initially entered a temporary restraining order that then the Ninth Circuit decided not to reverse. So the state of Washington, and eventually joined by a number of other states, filed a lawsuit against President Trump seeking to block the executive order. The state itself filed this lawsuit. It wasn't an individual party, it was the state itself. The lawsuit here resulted in the Western District of Washington issuing a nationwide temporary restraining order. Now, to obtain a temporary restraining order, basically there's four requirements. One is that the plaintiff here, that Washington has to show a likelihood of irreparable harm, that the balance of harms favors the movement, the plaintiff, the state here. The key thing I'm going to focus on is this third element, a likelihood of success on the merits, and that the public interest favors the injunction. Now, the Western District imposed a temporary restraining order blocking enforcement of the executive order nationwide with very little analysis. After a hearing, after the issue had been vetted before the district court, the court basically just issued a brief few-page order blocking enforcement of the executive order. The government then sought an emergency stay in the Ninth Circuit. Now, this raised some interesting procedural questions because, as we talk about in civil procedure, you usually cannot appeal a judgment, you cannot appeal an order unless you have a final order. So a temporary restraining order is not viewed as a final order, so this really should not have been initially appealable. However, the Ninth Circuit treated the temporary restraining order as a preliminary injunction. And as we talked about in civil procedure, an injunction is an interlocutory, it is an appealable order before a final judgment. And so the Ninth Circuit basically said, even though this is framed as a temporary restraining order by the district court, we're going to treat it as a preliminary injunction so that we can hear this appeal. It's framed as, the court says, we can treat it as a preliminary injunction for the reason that it's going to be in place for longer than 14 days. A temporary restraining order is only allowed to be in effect for 14 days, and typically a TRO, temporary restraining order, is issued without any sort of adjudicatory process or without any adjudication between the two parties. Usually what you're going to see with the TRO is one party is requesting the relief, the other party doesn't have a chance to respond. It's all happening very quickly. There's no adversarial process. And the TRO is entered for a couple of days until we get to the preliminary injunction stage. Ninth Circuit says we can treat this, in fact, as an injunction because it's going to be in effect for a longer period of time, more than 14 days, and there actually was some adversarial process here. The court held a hearing and it decided the motion on its merits. So the Ninth Circuit treats it as an injunction and therefore is able to actually go to the merits. And the Ninth Circuit, unlike the district court, gives us a relatively detailed opinion here saying that the plaintiffs, the state of Washington here, is likely to prevail on the merits. Now, technically, because it's the government seeking relief at this stage in the proceeding, an emergency stay in the Ninth Circuit, the government has the burden of proof. So with those four elements I mentioned, the federal government had the burden to show that there was no likelihood of irreparable harm, the balance did not favor the state, they had the burden of proof. But it's really the same inquiry. And before we get there, though, as you probably learn in constitutional law, anyone who's filing a lawsuit needs to have standing, right? The federal the federal courts can only hear cases or controversies. Any party that is bringing a case needs to have standing. They need to be able to show that they have a concrete and particularized injury, that injury was caused by the defendant, and the court is able to redress that injury. The government here, the federal government, argued that the state of Washington, and at this point Washington is joined by other states, but they argued that the state doesn't have standing because the state itself is not injured, and any sort of injury that was caused was not caused by the defendant. The Ninth Circuit, though, says that the state did suffer an injury distinct from that of its citizens because its public universities, an arm of the state, were injured. And this is really true across the nation. Major research universities were injured by this travel ban. And that's because faculty members are stranded outside of the country. They're prohibited from going to conferences. A big factor is students who are planning to come to the United States are now not allowed to come to the United States, and so the universities are losing revenue. In a very real sense, they're also losing prestige as they're losing faculty members and students. And so the court says because the public universities are injured by this travel ban, the state has standing, which is really, it's not unique, but it's unusual for a state to have standing. Usually an individual citizen would have to file a lawsuit. But the court says because of that harm to the university, the state itself has a concrete and particularized injury. court then also says that the state, or really what they're technically saying is the government has not shown that it's unlikely for the state to succeed on the merits. The district court had found that it was likely that the states would show that the travel ban was unconstitutional. And the court really walked through three arguments here. First, the federal government argued that the president had unreviewable authority to suspend entry into the United States. And in doing so, he was looking at the president's powers with respect to foreign affairs, which, as you hear in constitutional law, are very broad, right? The president is the primary repository of federal power over foreign affairs. And in fact, when you look at the Youngstown case and you see, well, what are the president's powers? Well, it depends on what Congress has done. If Congress is authorizing the president to take an action, then really the president acts with the full scope of federal power. And the government tried to argue that, hey, Congress has authorized the president to limit entry into the United States of any class of people, with no distinctions, any class of people. And so the government tries to argue that this is the president acting with the authority of Congress. Presidential power is at its peak. The president can do anything. Its authority, the president's authority here is unreviewable. The Ninth Circuit says that that is wrong. Ninth Circuit rejects that argument. And it does so, and I think a very convincing way. It says that, yes, the president's and Congress's power is plenary with respect to this. Plenary meaning that there are no limitations on what the president and Congress can do with respect to setting immigration policy inherently. You know, it's not as if there's federalism concerns with immigration policy. And the Constitution gives Congress the power to set an immigration and naturalization policy. So they have authority to set an immigration policy. However, that plenary authority is not an unlimited authority. There's a difference. The other limitations within the Constitution continue to apply. When exercising that authority to set an immigration policy, the president and Congress cannot violate the rest of the Constitution. Specifically, what's relevant here, they cannot violate the Due Process Clause or the First Amendment. Those are the two issues that the Ninth Circuit found that were problematic here. So moving on to those arguments, you know, they reject that unlimited, unreviewable argument from the president, and they say that no, really they focus on the Due Process Clause. The Ninth Circuit says that this violates the Due Process Clause, or at least there's a likelihood that it does. And it's really a pretty straightforward analysis from the Ninth Circuit. They rely on procedural due process. As you may recall, procedural due process says that the government cannot take away life, liberty, or property without due process of law. So what you want to do with the due process type case is you ask, is there a life, liberty, or property interest that is being infringed upon by the government? And then you ask, if there is such an interest being infringed upon by the government, was there adequate process given? Now, process, what type of process is required is going to depend on the circumstances, but it's going to at least involve some notice and opportunity to be heard. Now, how much notice before the deprivation, after the deprivation, what type of opportunity to be heard? Do we need some sort of a formal proceeding? Is a written opportunity to be heard, you know, writing in an appeal, is that good enough? Well, that's the Matthews versus Eldridge balancing factors that you may have heard about. The court's going to weigh the plaintiff's interest in their right, their property, or their liberty, the defendant's interest in being able to act quickly without providing the process, and the likelihood that additional process is going to make for a better decision. And the court says here it is very clear that this executive order infringes on protected interests of U.S. residents and others as well, basically. They say that case law clearly shows that the due process clause protects liberty or property interests of people within the United States. It is not limited to U.S. citizens. When you read the due process clause, it applies to all persons within the United States. It does not say U.S. citizens. And there's case law out there saying that this applies to people who live in the United States, even people who live in the United States illegally. But certainly it applies to permanent lawful residents, green card holders, which the executive order, this original executive order, applied to. And so the Ninth Circuit has a very easy time in saying that, look, this affects the due process rights, the property interest, the entitlement of the legitimate expectation of being able to travel. That it limits that right to someone who's entitled to due process, and no process is being given. This first executive order was effective the day it was signed on January 27th, and there was really no way for a green card holder, for a permanent lawful resident, to ensure, to be able to appeal the decision. There was no notice. There was no opportunity to be heard. There was no process being given, and there was clearly a liberty or property interest being taken away. And so the Ninth Circuit has an easy time in saying that this is a due process violation. Now, the government's primary argument here was that the White House counsel had clarified that the first executive order did not apply to lawful permanent residents. The Ninth Circuit rejects that argument by saying you cannot moot a case through voluntarily stopping the behavior. That's a normal, that's a doctrine you may have encountered in your con law class. Sometimes it's called the voluntary cessation doctrine. A defendant cannot moot a case or make a case no longer an act of controversy just by saying, I'm going to voluntarily stop doing the unconstitutional behavior. There needs to be some sort of guarantee. There needs to be some sort of reasonable expectation that the unconstitutional behavior will cease. And here the Ninth Circuit says we don't have that. We don't have that because we don't have anything from the president guaranteeing us that this will not apply to lawful permanent residents. Ninth Circuit also says, incidentally, that this applies to more than just lawful permanent residents. The Due Process Clause protections apply to people on non-immigrant visas, so people here for work reasons, travel reasons, sightseeing, visiting family members, any sort of number of other purposes. So they hang their hat really on the green card holders, but they say that this applies more broadly. The Ninth Circuit also says there are serious Establishment Clause concerns here. And I want to save that for the second travel ban. I'm going to go into this in more detail. But the Ninth Circuit, it says basically that it's going to rely on the due process argument, but it flags as serious concern the idea that this could violate the Establishment Clause of the First Amendment. The Ninth Circuit then goes on to irreparable injury. So, as I mentioned, one of the requirements for a temporary restraining order or a preliminary injunction, and the requirements are the same. So you need to show that there's a likelihood of success on the merits. You also need to show a likelihood of irreparable injury. And you need to show that the balance of harms favors the granting of the injunction. And the government tries to argue here that, hey, the president is due deference in its decision that this order is justified by national security interests. And so the balance of harms, the irreparable injury really favors the government because the courts shouldn't interfere with the president's determinations regarding national security. The court says that there's a difference between deference and just abdicating the judicial role, basically. Yes, the court will give deference to the president's determination that the order is needed in favor of national security, but it's still going to look to see whether there's any showing of harm. And the court says the government has produced nothing beyond just the bare assertions of attorneys that this order is needed to protect America. This is true notwithstanding the fact that classified material can be submitted to federal judges under seal so that it is not distributed to the public. Federal judges see classified information all of the time. If President Trump actually had a legitimate national security reason for this order, some sort of imminent threat, something that isn't known to the public, that should be submitted to the Ninth Circuit, and they can look at that information, and nothing was submitted. And so the court says we can't just abdicate the judicial role and let the president make this decision. We need to decide something. Yes, we'll give deference to the president, but he needs to give us some evidence that we can defer to, not just a bare assertion. So the Ninth Circuit denies this appeal from the temporary restraining order, and the injunction is held in effect. Now, and incidentally, it's a nationwide injunction, which may sound a little bit strange because, as you know, the Western District of Washington just covers half of one state of the 50 states. The Ninth Circuit, even though it's the biggest circuit, it covers California and surrounding states to California, Alaska, Hawaii, other states surrounding California, but not the entire country, of course. They issue a nationwide injunction, though, because they say, relying on Fifth Circuit precedent that had been decided against President Obama's very different executive orders respecting immigration. The Ninth Circuit cites that, and the Western District of Washington cite that to say we need to have uniform immigration policies. And it wouldn't make any sense for the travel ban to be enjoined just in Washington or just in the Ninth Circuit, and then have it be in effect in the rest of the country. That really wouldn't work, especially the way that international travel is structured. You might fly into New York and then fly over to Seattle or something like that. And so if you need national uniform immigration policy, and so if we're going to strike it down in Washington, we're going to strike it down througthroughout the entire country. Now, so that's the original travel ban. President Trump sees that his travel ban is struck down. It was one of his signature campaign pledges, was that he was going to institute extreme vetting, ban the entry of Muslims into the United States. And so he didn't want to let this go, right? So he signs a second travel ban relatively recently on March 6th that seems to be designed to avoid or to get around the concerns that the Ninth Circuit had raised. It's different in that it applies to 6 countries rather than 7. Iraq is dropped from the list. Now, that's really more, I think, a practical determination that I won't go into because it's beyond my expertise. I don't think that's constitutionally driven, but Iraq is dropped from the list. No longer applies to Iraq. Importantly, it does not apply to visas that have already been issued. That seems to be designed to get around the Ninth Circuit's due process argument, because their primary argument was that permanent lawful residents won't be able to travel anymore. People who already have visas basically have a due process interest in those visas. They need notice and an opportunity to be heard before those visas are effectively taken away. And so the new travel ban only applies to the issuance of new visas, so that if you have a visa already, that's not going to be affected. It also drops the provision that would have granted preference to minority religions in the refugee program. That's because the Ninth Circuit had flagged that provision as problematic under the Establishment Clause analysis of the First Amendment. It also included possible exceptions to the travel ban that would be discretionary uh, with executive officers. It would be up to them what they want to do for people who have family members in the U.S., who have business interests in the U.S., who have educational reasons for coming to the U.S., and other reasons. And so if you look at how this new travel ban is different, it also, importantly, it was signed on March 6th. It was not due to take effect until today, March 16th. So it was much less immediate. Um, and so, and there are these exceptions that were in place as well, as I mentioned. So that was supposed to make the effect of it less immediate. It was supposed to make it less of an injury, and less in the change where we're dropping the preference for minority religions was supposed to make it less of an establishment clause concern. As I mentioned, having it apply only prospectively to new visas was supposed to alleviate due process concerns. And so this travel ban was, and Trump's advisors went on national television saying this new travel ban was designed to fix the constitutional problems that the Ninth Circuit had raised. Just yesterday, I guess I don't have a slide on this because it just happened yesterday. But just yesterday, 2 district courts issued nationwide injunctions on this revised travel ban, so that it essentially has not yet taken effect. It was supposed to go into effect today, but yesterday the District of Hawaii issued a temporary restraining order, and the District of Maryland issued a temporary restraining order with respect to the ban from those 6 countries. It did not issue a temporary restraining order with respect to the refugee program, though the District of Hawaii did. So the whole thing is frozen right now. Now, I anticipate, and Trump has said within the last 24 hours, that these decisions will be appealed. Hawaii would be appealed to the Ninth Circuit, which already did not look favorably upon the travel ban. And Maryland would be appealed to the Fourth Circuit, which may be more friendly territory for Trump. It's more conservative than the Ninth Circuit. But it's unclear how this will be resolved. It's going to be changing, week to week. What we're going to see here. Also, keep in mind that just because we have a temporary restraining order doesn't necessarily mean that those courts would issue a final decision against the travel ban. These are preliminary findings. The courts have basically found that there is a likelihood of success, not that the plaintiffs are entitled to relief. But with those caveats, I spent the better part of the morning reading through the Hawaii and the Maryland decisions, so I wanted to give you my take on them, exactly what the courts were doing. Now, the standing issues were a little bit different. I don't want to get into the weeds on that because it's probably not what you're concerned about as much. They largely relied on the Establishment Clause argument, that First Amendment argument. I said the Ninth Circuit flagged the Establishment Clause as a legitimate issue, but it really based its decision on due process. Well, because of the changes that were made, these courts did not discuss the due process arguments. They found that because there's a likelihood of success on the Establishment Clause, we don't even need to get to the due process arguments. They're in the case. The plaintiffs, again, argued due process, but really the decisions are all about the Establishment Clause. And under the Establishment Clause, there's really a 3-part test that we look to find if there's a violation of the Establishment Clause. It's sometimes called the Lemon test because it was decided in Lemon versus Kurzman, a Supreme Court case. And under the Lemon test, for a law to be constitutional and not violate the Establishment Clause, there's 3 things that must be true, and all 3 of these have to be true, right? The law has to have a secular, non-religious legislative purpose, and that has to be the primary purpose of the legislation. Second, the principal or primary effect of the legislation must neither advance nor inhibit religion. And third, the legislation cannot foster excessive government entanglement with religion. Now, both of these decisions focus on that first prong and say that it violates the travel ban. There's a likelihood of success based on the argument that the travel ban does not have the primary purpose that is secular. Instead, the primary purpose, they say, is religiously motivated. And how do they get there? Well, the government tries to argue that because this is an act of the president, we should only look at the face of the statute, the face of the executive order, and what was actually what Trump officially did as a president. The court strongly rejects that. The Ninth Circuit had rejected that type of argument as well. The District of Hawaii and Maryland do the same thing. They say, no, look, in all of the major Supreme Court cases and other lower court cases, you look at the full context. What would a reasonable, objective observer who had the full context, what would they think, right? What would they think was the primary purpose of this? And the courts say, well, it's pretty clear that they would think the primary purpose was to disfavor Islam, to go after Muslims. And that in and of itself is an impermissible motive that's going to make you fail the Establishment Clause test. They find that by looking primarily at Trump's statements as a candidate, where he says very explicitly that he wants to ban Muslims from coming into the country. The District of Hawaii says there's unrebutted evidence of religious animus driving the executive order. Trump calls for a Muslim ban, and then when he turns that into this ban on immigrants from certain countries, he's asked, is this the Muslim ban, or are you retreating from the Muslim ban? And he says, no, I'm not retreating from the Muslim ban. I'm expanding the Muslim ban. He doesn't disavow the Muslim ban. He says this is the Muslim ban. We have those explicit statements from the president himself. We also have statements from his surrogates. Giuliani and Miller both say that the president was trying to constitutionally achieve the Muslim ban. Well, that's not constitutional. It's facially neutral. But if facial neutrality was enough, then basically it would be the Establishment Clause would be meaningless. All modern Establishment Clause cases, really, the legislation is going to be facially neutral. But that's not enough to make it constitutional. The court looks behind the facial neutrality, looks at the statute itself. So I'm seeing a question here. How long would this cycle keep us going between issuing executive orders and having them injuncted? Can this go on through the whole term of Trump's presidency? I think it could. The District of Hawaii is very clear at the end of its decision to say this does not mean that the president can never issue a constitutional executive order on this topic. It's just we need to look at with the full context, right? We need to, when determining intent, whether there's an intent, religious intent or not, you need to look at it with the full context. And the context right now is that this is religiously motivated. So Trump has said publicly, within the last 24 hours, that he's going to appeal this all the way to the Supreme Court. My guess would be that's what he's going to do. Now, last time after the first executive order, obviously he drafted a new one that he thought would survive constitutional scrutiny. I don't know. I mean, he could just draft a new one. I don't know what it would look like. This one is already different than what he wanted. And so my guess would be that rather than drafting a new executive order, he's probably going to take this on appeal to the Supreme Court. And so it's going to go through the Ninth Circuit, maybe the Fourth Circuit, possibly even others. There's litigation all over the country on this. and then up to the United States Supreme Court. That could lead to an interesting decision as well. I have no idea how the Supreme Court would rule on this. When I read the District of Hawaii decision, the District of Maryland decision, they read pretty strongly to me. I could see the Supreme Court striking this down. Of course, it's hard to predict what would happen there. But my guess would be that if the Supreme Court strikes it down, he'll have a hard time going forward. He'll probably complain an awful lot about it and use that as a need to get more of his judges on court. But I think it's unlikely that he's going to continue this process of issuing new orders. Last time he basically, the first executive order, he told the Ninth Circuit, look, we're not going to pursue this. We're going to issue a new one. I think it's unlikely he's going to do that this time. I think he's just going to appeal this all the way up rather than issuing a new order. Technically, though, you're right. He could just keep issuing new orders. And so with this order, he gave a 10-day window before enforcement. Excuse me. With the first one, he didn't. So what would happen if let's say that tomorrow he issued a new executive order and it said it's effective that day. Excuse me, I'm sorry, I've been a bit under the weather here. Well, the result there would probably be that, the executive officials are going to do whatever Trump says. That would be my guess. And then we're going to have plaintiffs filing lawsuits. We're going to have, especially in Hawaii, Washington, Maryland, these cases, those plaintiffs in particular are going to try to get the new order enjoined, and the courts will probably act relatively quickly. I don't think we can play that sort of whack-a-mole game too much. It would get to be really undermine the rule of law if he would do that too much. So my guess is he'll just take it on direct appeal and hopefully accept whatever decision we get ultimately from the Supreme Court. That process, of course, can take a long time, though. It takes a long time for a case to find its way up to the Supreme Court. Okay, so District of Hawaii found that there were a lot of statements from Trump saying that the purpose here was religious. And then when you're looking at purpose, well, you also look to that stated purpose, that secular purpose. What is the stated secular purpose? Well, the stated secular purpose here is national security. District of Hawaii says, we don't believe that that is the main purpose because it looks pretextual. It doesn't look like the real purpose. It doesn't look like a rational purpose. Because, again, like the Ninth Circuit had said, there's no evidence that this order actually protects America. The executive order cites one incident of someone being arrested for terrorism-related activities from a person who came here from one of the 6 listed countries. That person was a refugee from Somalia who came here as a child. It doesn't make sense to ban people from 6 countries because one person, excuse me, because one person from one of those countries was planning a terrorist act. Court also says that the delayed timing of the orders shows that there really was no urgent national security need. I apologize. Court also says that the focus on nationality rather than other factors like recent activities is irrational and shows that security is really not the purpose here. The purpose is fulfilling that campaign pledge to ban Muslims. The government makes basically 2 arguments here. One I've already mentioned is that idea that you should just look at the face of the statute. Anything he says during the campaign trail shouldn't be considered. Court rejects that argument, I think justly. because if you look at all of the Establishment Clause cases, they say you look at the full context, look for real intent, not just the facial language of the statute. There's no reason why we wouldn't also look at what he said on the campaign trail. Second, the government argues that this isn't a Muslim ban because it applies to people who are not Muslim within those countries, and most of the world's Muslims don't live in those countries, basically. It doesn't totally ban all Muslims, and it bans some people who are not Muslims. The court absolutely rejects that argument. It says that basically you don't have to ban all Muslims for it to be for the purpose to ban Muslims, right? Those countries are predominantly Muslim. 90 to 99% of the citizens of those 6 countries are Muslim. And so it's a step towards banning Muslims, and it is endorsing a view that Trump has stated on the campaign trail, which is that Muslims are dangerous and that Islam is not a valid religion. These are things that he has essentially said, and this ban furthers those ideas and is infused with those ideas, and so the court says that there is this religious purpose there, and any sort of national security purpose is secondary. There's also statutory arguments that the District of Maryland talks about quite a bit. For time purposes, I'm going to skip over that because I want to leave time for questions, which means I'm not going to talk much about these last 2 topics because, as I said, the travel ban is really what we've had a lot of litigation on, right? And it's probably foremost in people's minds, but there's so much going on with President Trump right now. I wanted to mention this briefly. So the president can keep issuing orders. There's nothing to stop him from doing so. And the president, the courts can't enjoin him from issuing new executive orders. The courts don't have the power to stop him from doing that. What they can do is enjoin enforcement of those orders after they've been issued. And that is likely to happen if President Trump continues to go down this path. And that's why I said a moment ago, I think that Trump would be unlikely to keep issuing executive orders on this topic because it's really just going to make him look weak, right? Because they're going to continue to get struck down in court. I think this second executive order was his best attempt at a constitutional executive order. And now that that's been struck down, I think he's going to fight this one. Really, if you think about it, all we have is 2 district judges saying that this order is unconstitutional. We don't have any decision from an appellate court, and we certainly don't have anything from the U.S. Supreme Court. And remember, the U.S. Supreme Court is relatively conservative. We have 4 Republican-appointed justices, and if he can get his 5th confirmed, it's going to be more conservative generally than your average appellate court. He's going to have a better chance of winning, perhaps, in the Supreme Court. I don't know, but that's probably what he is thinking. Okay, so the second topic I wanted to mention briefly is immigration enforcement. Trump issued an executive order here that he called basically protecting, enhancing public safety in the interior of the United States. And it involves a number of components here. There's his signature campaign pledge of building a wall between the United States and Mexico. And then he wants to hire a number of new immigration officers. And those issues don't really involve constitutional problems, but it is important to keep in mind that the president can't do these things unilaterally. And that's because it costs money. And so President Trump needs to get funding from Congress. And in fact, again, this is just breaking over the last couple of days. Trump is asking Congress to fund the hiring of 100 new government lawyers and 1,500 new ICE officers to help ramp up enforcement of the immigration laws. He's also asking for an extra $1 billion from Congress to fund additional deportation activities, and he's asking for $2 billion as a start, a down payment on building his border wall. And so I just mentioned that because these are not things that President Trump can actually do without the support of Congress. And so that's going to be interesting to watch our system of checks and balances, how that will play out, because Congress seems much less enthusiastic about these goals than President Trump. But we'll see. The second two bullet points I have here do raise very interesting constitutional issues. First is his revitalization of secure communities. This program, under this program, basically whenever the local police arrest anyone, that information, the booking information, is shared with ICE, with Immigration Customs Enforcement. And ICE, the federal government under secure communities program asks for certain information to be inputted and then shared. And then when ICE sees who's been arrested, they can issue detainer requests and ask for the local government to hold on to people. Let's say someone's picked up for a minor violation. ICE can ask them to hold that person in jail until ICE can show up and initiate deportation proceedings and take them to a federal facility. So that's secure communities. What's constitutionally interesting about this is Congress cannot force the states to implement secure communities. They can't force the states to honor those detainer requests, can't force the states to share all of the information at once. Now, practically, the states always share information with the federal government because they want to clear information with the FBI. If they arrest someone for burglary, let's say, they want to make sure that they're not a wanted serial killer. But they can't force them to share all information, including, immigration status, or collect that information. Can't force them to input that into the state system. More importantly, though, they can't force them to issue that detainer request. So a number of cities, so-called sanctuary cities, have decided that they're not going to honor those detainer requests. If ICE asks them to hold on to someone they've held in custody, they're just going to let them go and ignore ICE. And that's the federal government cannot constitutionally require the states to participate in secure communities because of Prince and New York. Those cases that you may have covered in your constitutional law classes, which say, it's sometimes called the anti-commandeering doctrine. The federal government cannot commandeer state officers and force them to enforce federal law. And so what Trump is doing, instead of trying to force the states to comply with secure communities, what Trump is doing instead is trying to use the spending power. Under the spending power, what he's trying to say is that that sanctuary cities are going to lose federal funding. Now, as you learn in constitutional law, there are limits on what the federal government can do under its spending power, though. When it places conditions on funds given to the states, those conditions cannot be coercive, so they can't take too much money from the states. The states need to have a legitimate option, and those conditions have to relate to the purpose of the funding. So it seems that likely that Trump, he hasn't given any specifics here, but if he wants to hurt sanctuary cities, all he can do is take away law enforcement related money. Personally, I think that's very unlikely given Trump's focus on law and order on the campaign trail. It seems unlikely that he's actually going to take money away from local law enforcement, even in sanctuary cities. So that issue there is rife with constitutional issues. And then I'll just mention here, the law and order claim. Basically, he's pushing for more stop and frisk, more. This is going to raise, I think, a number of constitutional issues, but it looks like we're running out of time for that. But I did want to mention in conclusion that for all of these executive orders, Trump is basically using security and safety concerns to justify what he is doing. Each one of them targets minority communities, and policy experts, which is not my expertise, I'm a legal expert, but policy experts say that this is actually counterproductive. Because with the executive order on immigration, for example, it's creating this false narrative that the United States is at war with Islam, which actually helps terrorist organizations recruit people. So it seems counterproductive to his stated goal. And all of these issues raise serious constitutional concerns. And so what we're seeing in the United States is the courts playing an important check on the president's powers in a way that I think is going to be in the headlines for years to come, really, probably for the rest of his administration to some extent. So, thank you.